Be ready. Start. The accident occurred on 23/5/1997. Exhibit P1 insurance policy was subsisting as on the said date. The third respondent was riding the scooter having registration number KL07/A9171, had a driving license. Its validity period expired on 30/1/1996. He renewed it later on 18/6/1997. As on the date of accident, he did not have a valid driving license according to the appellant. Therefore, the appellant did not have the liability to indemnify the owner. The appellant submitted. A person without an effective and valid driving license is not duly licensed. Consequently, there was breach of the terms and condition in the policy. On the basis of this violation of policy conditions, the insurer can plead immunity from the liability to indemnify the insured. Policy contained a condition that only those having an effective and valid driving license alone can drive the vehicle. In this case, the rider did not have an effective and valid license as on the date of accident. This breach of the policy conditions enables the insurer to avoid the liability in terms of the policy. Para. Reliance was placed on the decision reported in Ashok Maratha vs. Oriental Insurance Cooperative Limited 1999 SEC 620 to contend that effective driving license means a valid license both as regards the period and type of license, and on the judgment in MFA number 500 of this court to contend that if the driver was not having an effective driving license as on the date of the accident, the insurer will not be liable to indemnify the insured. It was also contended, placing reliance on the decision in New India Assurance Cooperative, that even if the insurer, if found liable to pay the award amount to the claimant, the appellant shall be permitted to recover the same from the insured. It was further contended, citing the decision in 2003 TAC 35, that when there is evidence to show that the driving license had expired prior to the date of accident, it was not necessary from an insurer to further establish that the driver was disqualified from holding the license. The appellant also submits that possession of an effective and valid driving license was a condition in terms of the policy. Para. On the other hand, it was contended by the claimant and the insured that the rider had been issued with a valid driving license on 22/2/1994. Therefore, he was duly licensed. Though the validity period of that license had expired on 30/11/1996, it had been duly renewed on 18/6/1997. This indicates that he had never been disqualified from holding or obtaining driving license. Whatever be the condition in the policy, in the terms of Section 149(2) of the Motor Vehicles Act 1988, the insurer can raise only points of defense statutorily allowed. Driving license is defined in Section 2 of the Act, and it does not make any reference to the period of its validity. Section 14 mentions about the period during which a driving license can be said to be effective. Stop.